Welcome to this presentation regarding the discovery module that we're covering this week. Want to spend some time going over the material so that you'll be in the best position to be successful on the assignment as well as the test or the final exam coming up. So let's go ahead and go into Module 10. I'm going to scroll down here and we'll see Module 10 is right where it should be. Okay, we see that we have an assigned reading, so I'm going to open that up. Not going to talk a lot about this, but be sure when you get a chance to look at the assigned reading, ideally before you complete the project. I know that we've talked about this in the past, but just a little reminder. My suggestion would be when you're listening to the lectures is to pause me at times so that you can look at the materials, especially look at the assignment materials, take notes, and even start working on the assignment as I am explaining how to approach it. That way you won't have to go back afterwards and listen to the lecture multiple times. If you pause while you're getting the information that you need, then you can incorporate that into your assignment, and hopefully that will be a more efficient way to handle the task that is at hand. So you'll see here's a little bit of information about the discovery process. I'm going to go back to Module 10, and then we're going to go into the discovery, the PowerPoint. I've already downloaded that. So here we are. I'm going to go to the beginning of the PowerPoint. We're going to talk about this in a few minutes. But let me go back. You'll see that we also have the discussion board. Always remember to participate in that. And then we have the actual assignment for this particular module. And then, of course, there's the SAT Grammar Boot Camp. Be sure to keep current with that. You may be tempted at times to wait and look at those maybe the week before a test, but it'll be much more it'd be a much more productive use of your time if you actually watch the videos during the week that they're assigned. Yours and my brain are not designed really to get a lot of this grammar type of information in a short dose, in a big dose right before a test. You're going to find that you have to spend less time studying if you prepare throughout the semester for things like this. So here we have the assignment for Module 10. There's no documents to open with this one, but as I'm reading here, I see that there is something called a sample document folder that we need to go to. So I'm going to flip on over here to sample documents. Go into the sample documents folder. And right down here you can see the notice of taking deposition form. I've actually already, let me go ahead and click out of that. I've actually already presented the document here, or have the document downloaded here. So what we're going to do today is talk about the PowerPoint, talk about the assignment, and look at the sample document and see what we want to do with that. Okay, so let's get started talking about discovery. We're going to be talking today about discovery requests. The discovery process is a really, really important part of the litigation process. Many legal professionals consider it the single most important part of that whole process. So definitely be aware that it's something that you're going to want to be very familiar with if you end up deciding to become a paralegal who works in the litigation area. Another kind of interesting thing about the discovery process is that it is probably the area of the case that the paralegal is most involved in. And so you have a greater level of autonomy and responsibility many times working as a paralegal in the discovery aspect of the lawsuit. So let's get started. So what is discovery? Well, discovery is the portion of the case that begins after the pleadings are done, but before trial happens. That long period of time, and it can go literally for months. In fact, it will go for months, sometimes even more than a year. And it is the part where both sides share the information that they have about a particular matter. Now, of course, let's say I'm on one side, let's say I'm the plaintiff. I, of course, want to hear the defendant's side. That's going to help me prepare for trial. It's going to help me have a greater understanding of the strength of my case and how I ought to approach settlement negotiations. So it's very obvious why I would want to know the other side's perspective on a particular case, or the facts that they are going to be relying upon, their theory of the case. But of course, even though I want the other side's information, I don't especially want to give the other side my information. There's no advantage to that unless I think I have a slam dunk fact that is really going to make the other side look at the case differently and be willing to settle or something like that. So I have a lot of interest in what they want to tell me, but I don't have a lot of interest in sharing with them what I have, what my secrets are. But the way the system is set up in the United States is both sides have to share the information, and they have to follow the rules that the parties participate in. This is for the civil litigation process. Obviously, for in the criminal situation, the rules are different. So this sharing of information is required, and what that means is at the end of the day when you're going into trial is that neither the plaintiff nor the defendant is really going to be surprised by anything that happens in a civil case. If you grew up watching Perry Mason or some show like that, of course Perry Mason usually represented criminal defendants, but so some of this analogy doesn't completely work, but you may recall there were lots of times where there was a surprise where sometimes even Perry didn't know what was going to happen next. That still happens in some criminal cases for sure, but it doesn't happen in civil cases very often at all because both sides know all of the good facts and all the bad facts. The jury, of course, doesn't know it, and the judge doesn't always know it, but the two attorneys and the parties obviously already know it. So discovery is the mechanism by which this information is shared. But before we get to discovery, we need to put discovery within a context. And so let's look at the things that happen before discovery. And that's the pleadings phase of a lawsuit. And the document that starts a lawsuit, if we're in federal court, is called the complaint. And the document, if we're in Texas state court, it's called a petition. And if you think about it, these names make a lot of sense. When we petition someone, we're asking for something, right? That's the nature of a petition. And so when you file a lawsuit, when you as a plaintiff file a lawsuit, you are asking the court to solve your problem. You're saying to the court, I've been wronged in some sense and I need you to help me get back to where I ought to be. So you're making a request of the court. But the term complaint also makes sense because, of course, when you use this word, you're saying, I'm complaining. I am unhappy about something that has happened. And so in the term complaint, you're focusing on what your grievance is. When you use the word petition, you're focusing on what you're asking for to solve your grievance. So the bottom line is you use this term in federal court and you use this term in state court. That's all there is to it. There's some state courts in different states may actually use a different term than petition, but that's our system here. When the plaintiff has filed his or her complaint or petition, depending upon the court that system we're in, the defendant will file an answer. And again, the name answer is also very suggestive of what it is. The answer responds to the complaint or responds to the petition. It gives the defendant an opportunity to present its case, and it's not only its response to the plaintiff's case, but also additional facts that it thinks are important to the case. An answer, even though the same term is used for state and federal cases, an answer is a very different document when you're responding to a complaint filed in federal court than when you're responding to a petition filed in Texas state court. But again, this isn't the lecture on pleading, so we're going to move on from there. But I wanted you to kind of have a refresher about what these mean. These are typically filed. It's sometimes the case that you start discovery before the answer is filed, but of course you're definitely not going to start discovery before the complaint is filed because there is no lawsuit, so there's no responsibility to engage in discovery until after there's a lawsuit filed. So after the lawsuit is filed, the parties engage in discovery, as we said, and it's a formal process. There's rules, detailed rules that say how, when, why, where, all of those good things. And so it's the playbook for how to participate in this. You know, just like if you're playing football or chess or any other competitive, I guess, endeavor, you're going to find that the rules, the party who uses the rules in the most subtle way, sometimes in the most creative, the most strategic way, sometimes gets better results. So the rules are there, they must be followed, but it is also important to keep in mind that the rules uh, uh, can be looked at in different ways, and the best legal professionals are aware of the fact that uh, rules provide opportunities to be creative and to put your client in the best position. Okay, so as said before, the purpose of discovery is to allow both parties to prepare for trial. That's the primary purpose, but there's also some secondary purposes. Another purpose it can have is to prevent surprise at trial. Going back to Perry Mason, there was always that moment in the trial where everyone's surprised by what one or more witnesses said, and that doesn't happen in civil cases very often at all. And that's a philosophical choice that our court system has made. Other court systems haven't made the choice. It's not the only good system to have. But we decided as a system, at least in the civil process, that surprises aren't very good because, or the idea is that it rewards the side that had the most resources to find out information, and it rewarded the side that kind of had the cleverest attorneys. And while certainly the quality of legal representation is really important to the results that you're likely to get, um, our system wants it to be primarily about finding the truth. And so if there's hide the ball kind of mentality going on, it can make it difficult for the jury to get the information that it needs. And sometimes information that would have been important never gets revealed if you don't have a system of sharing information. So yes, the adequately preparing at trial is an important concept, but also the desire to avoid surprise at trial is another important concept. And finally, and this is sometimes the most important aspect, because of course most cases settle, is that discovery lets both parties objectively and reasonably evaluate the strengths and weaknesses of their case, as well as the strengths and weaknesses of the other case. Discovery is certainly about asking questions and getting information from other parties, but you can also use some of the discovery tools to get information from non-parties, witnesses perhaps, or employers or other people involved in a particular situation. So what are the goals of the discovery questions? Well, the first is to seek documents and other evidence that is relevant to your case. You want not just facts that are good for your case, but you also want the facts that are bad for your case, because obviously if it's a fact that's bad for your case, the other side intends to use it. You want to know about it so you can prepare your response to that. You may have a way of showing that fact isn't as strong as it initially appears, or you might have ways of punching holes in it to demonstrate that maybe that's not the correct fact, or you may have some additional evidence that puts that fact in a different context. Lots of different tools you can have, but if you don't know about that piece of evidence, it's almost impossible to prepare for it. So that's important. Of course, the other thing is you want to avoid surprise at trial and also the settlement issue. Okay, we have discovery in both civil and criminal litigation matters. In the criminal context, though, discovery is a very different thing. There are constitutional protections against self-incrimination, and so a criminal defendant never has to share um, inculpatory, meaning evidence that makes them appear more guilty, to the prosecutor. The prosecutor, though, is required to share both inculpatory and exculpatory evidence about the defendant. So, of course, inculpatory is evidence that tends to make the defendant look more guilty, and exculpatory evidence is evidence that tends to make the impression that the defendant is less guilty. And those are very important constitutional issues way beyond this lecture. If that's a topic that interests you, I definitely encourage you to consider taking criminal law. But we're going to be focusing today on civil matters. And discovery is, of course, much more extensive in the civil context. As I said before, basically everything gets shared before trial. Okay, so let's go through the most common discovery tools that we'll be seeing in litigation. Interrogatories are usually the first discovery tool that's used. In fact, in both the Texas and the federal system, there's some automatic questions that get generated really very, very early in the litigation process. Interrogatories are written questions, and You send it to the other party. You can't send these to non-parties. And the other party has to answer those questions under oath. And typically they have 30 days to answer those questions. You may be wondering, well, why is interrogatories only allowed, are you only allowed to give interrogatories to the other party? Well, interrogatories are difficult to respond to. You can spend hundreds of hours, thousands of hours sometimes responding to interrogatory requests. And so it doesn't seem reasonable to require non-parties, kind of witnesses or whatever, to spend that much money and the many resources in answering the questions. So they are limited to parties to the litigation. Depositions is another important tool, and that's the uh, part of that's what we'll be doing in this assignment, is working on the notice of deposition. And they are similar to interrogatories. The two big differences. One is that interrogatories are written questions and depositions are oral questions. The other big difference is that unlike interrogatories, which are only to another party, depositions can be to another party, of course, but they can also be to witnesses. And again, the idea here is that sitting for a deposition, though certainly not fun, is much less onerous on that witness than answering interrogatories, because the witness doesn't have to do anything to prepare for the deposition, although witnesses typically do. But the witness, especially a witness who doesn't have any skin in the game, who doesn't have any reason to be concerned about the answers that he or she gives, can just show up at the deposition and answer the questions. In most depositions last maybe 2 to 4 hours. There's certainly depositions that last longer, but especially if it's not a major witness, the witness may find that he or she is only needed for an hour or two for the deposition process. And our system says that's not an unreasonable amount of time to expect the witness, the non-party, to be involved in it. Like interrogatories, the answers are under oath. So there's the pains and penalties of perjury apply. So we have perjury here, which of course means under oath, and then we have under oath here too. After the deposition, the court reporter who was present, who actually put the witness under oath, will create a written transcript. And I say written, usually it's an electronically typed transcript that will be available for both sides to look at. If of course both sides have to order the transcript if that's what they want. So that is the deposition process. Generally how it works. Then there's also things called requests for productions. Many times requests for productions are paired with interrogatories. Interrogatories are just questions, but let's say you have a question about, describe all the documents that you have that would be relevant on this issue. Well, then very likely you'd want to pair it with a request for production saying, produce all those documents that you mentioned in interrogatory 17. They can be documents. They can be electronic data, such as email messages, scanned documents that are in a system, voicemail, um, uh, any data really that's in a computer. They can also be physical evidence. So let's say there are pictures, or there is, let's say it's a product liability case, and the question is how a particular item was designed. Well, examples of that item, or information and models of how that item was developed, those types of things can be part of request for production. So many times it's paired with interrogatories, but certainly requests for productions can be completely separate from interrogatories. That's a strategy that the legal professionals involved in the case will come up with. There can also be requests for admission, and these are oftentimes the last discovery tool that's used. Again, these are written. In fact, everything on here is written except for our deposition questions. These are written questions. They can only be to another party, and it's kind of like a true-false test. Excuse me. Having a little technical difficulties here. So, in the sense that they're true-false questions, that the party has to admit or deny each statement. There's a couple of other things that the parties can do, but generally it's an admit or deny situation. Obviously, the most common is the written form. Depositions can be quite expensive, and so unless the case is very big, it's common for the parties to only take a handful of depositions while they'll be gathering data and other tools through the other techniques as well. And again, typically, you're going to have 30 days to respond to written discovery requests. A deposition, obviously, the deponent or the person being asked the questions actually answers the questions at the deposition. So that's a real-time response. We already talked about that there's certain information that is kind of automatically exchanged in both the federal system as well as the Texas state system. And these are set interrogatories, and they request things like, who's the witnesses? What's the contact information for the witnesses? How are damages calculated? Things like that. During a deposition, the attorney who has noticed the deposition will ask questions of the deponent. The deponent will be present. The attorney asking the questions will be present. The attorney for the other side will be present. The court reporter, who is the officer of the court who administers the oath and records the deposition, will also be present. Many times the parties are present, and many times paralegals are present as well. The deponent can be lots of different people. It can be the opposing party, certainly routine to depose the opposing party, or it can be a witness. It can be and the witness may be on the side of the opposing party, or maybe just an innocent bystander, maybe someone who saw the car accident. Most of the time, one does not depose one's own witness because you can interview your witness whenever you want to. So why would you choose to interview your witness in front of the other side? Anything that is said during a deposition has the potential to be used in court. It can't always be used, but there are times where it can be used. So that's an important part of the deposition. If a witness is not going to be available for trial, either because they are beyond the scope of a subpoena for trial, or perhaps they're in poor health, or incarcerated, or perhaps they might not live to see that. So there can be important reasons. Those are oftentimes called perpetuation depositions because you're trying to perpetuate the testimony. But even if you anticipate that the witness will be available to testify at trial, the deposition testimony can still be used in certain situations, oftentimes to impeach the witness. So let's say the witness said one thing in the deposition, but during his or her live testimony says something different. Well, if you happen to have preferred the first testimony, testimony of the deposition, then you very likely will want to try to get that deposition testimony in, and so that can make a secondary use for the deposition. A third really important use of the deposition, and many people would say this is the most important use, is that it can be used as a document for dispositive motions. A dispositive motion is something like a motion for summary judgment. And after the discovery process is completed, there's a window of time before trial where both sides can consider whether they want to file dispositive motions. And if one side chooses to file a motion for summary judgment, then very likely items that have been received and exchanged through the discovery process will be exhibits to that particular motion, and so will be used for that. And certainly depositions are routinely one of the documents that are used for that purpose. So let's take a glance at what discovery requests look like. Okay, well, the first thing is a discovery document is going to have exactly the same caption as the pleading in the case. So if you are representing the plaintiff, you can literally take the caption that you used for the complaint or the petition and cut and paste it into your new document, into your interrogatories or your notice of deposition or whatever that document might be. If you're the defendant, then you can use, of course, use your answer, or if you're having to respond to discovery before you filed your answer, you can look at the complaint or the petition and see what the caption should look like. Be sure to include the caption in this form, and you're not going to change anything about caption. I mean, yeah, the style of the case, the caption, case caption. The only thing that will be different about the caption will be the name of the document that you're going to be creating. So here's some examples. If you are in Texas District Court, you might have a caption like this one with Dawn Marie Phelps, Trevor Fuller, Gary Hart being the plaintiffs in this case. Let's look at a couple of features of this. This particular litigant happened to capitalize all these names. That's a common way of doing it. It's not necessary. You can see that they put a comma after all of the names and that they indented plaintiffs. That is common to do. So please indent, you have to indent that far, but indent a little bit the word plaintiffs. Most time people are not going to capitalize the word plaintiffs. They're going to put another comma here. They're going to have a lowercase v with a period representing, of course, verses. Then they'll have the names of the defendants. If you've capitalized the names of the plaintiffs, which is fine, you capitalize the names of the defendants. If you did not, if you only capitalized the first letters of the names and you'd only capitalize the first letters of the names of the defendants, you're going to put a comma here. You're going to indent the word defendants. And again, if it were just one defendant, you just say defendant to the exact same level that you have the word plaintiff, and you'll end it with a period. In Texas State Court, you're going to have the cause number. You'll have it right here. Now, if you're looking at the petition, this will be stamped on here. It won't be written or typed in here. It'll be stamped many times. But if but beyond that, of course, after the initial petition is filed, then you're just going to type in the cause number. There's no need to have an underline here. In fact, I would say don't do an underline here. Just type the number where it goes here. Then you can see they list the court in the district court, and then you'll have a court number. Again, you won't keep the underscore. You'll write the 107th district court, judicial court, and then you'll have the county that it's in. Again, all of this can be capitalized if you want, but there's no need for it to be. In the middle, you'll have your section signs. So you want to have that for each line. You want to have it at the approximate middle of the document. The federal district court caption is also pretty similar. Instead of having the cause number here, though, you're going to have the cause number over here. Many times civil action number is going to be abbreviated. Again, you're going to actually type the number here. You're not going to have an underscoring. Over here in a state court is where you put the information about the court. In federal court, though, it goes on top. So you're kind of flip-flopping this information with the case number between state and federal court. And again, you have the style over here. This isn't the best presentation because after Potter you should have a comma and you should have plaintiff, comma, and then the Chamber of Secrets, LLP, comma, and then have defendant, period, after that. This is an example of a county or probate court or whatever, and you can see it's a similar a style to the one that we had up here. So let's go forward. So the title of the document will identify the type of discovery request. And in Texas State Court and federal courts in our area, the title is going to be right here centered. So it'll be here for Texas State Court underneath the caption, and it'll be here centered in Texas Federal Court under the caption. There are some state and federal courts who put it somewhere over here where we put the court information in state court, or we put the civil action information. So if you're filing in a different location, you may want to see where they actually put the name of the document. You'll also want to make sure you have a footer on the document that precisely mirrors the name of the document. Make sure it's the right font, and make sure, typically you're going to want to go with a 10-point versus a 12-point. So here's some things to keep in mind. When you're drafting interrogatories, you're largely going to use open-ended questions, not yes-no questions, but things like, what happened on this day relating to the car accident or whatever. In the request for production, you're going to ask for lots of things. Again, your goal is to get as much information as possible, so you're going to want to say, hey, give me all the documents that are documents, data, lists, tangible things, whatever. Your goal is to set a very wide net to get everything in. You may end up having a lot more than you need, but it's better to have more than you need and not use it than to miss asking the questions that's going to get you the document that you really need. Where I talked about a request for admission, and you may be thinking, well, why do I need to do request for admission? Well, you don't, and that is one of the discovery tools that is not always used, but it can be very handy. Typically, courts don't give the parties all the time that they would ideally like in a perfect world. So a party might have enough witnesses and evidence to, for example, present a case for 5 days, but the judge may say you're only going to get 3 days. So then that party has to start thinking, well, what can I cut out? And one smart strategy for deciding what you can cut out is look at the facts that there really is no dispute about. And so if the other side agrees, for example, if the other side agrees that he was driving the car that was involved in the accident, you don't have to spend a lot of time establishing that. And so request for admission can be very useful in that sense. Request for admission can also be useful to discover maybe some hidden facts that were points of controversy that you weren't aware of. You may have been assuming all the time that he's going to admit he was driving the car. But when you actually ask the question, you may find out, oh no, my assumption was wrong. Well, better you find that out now than at trial. It's not necessary to use the word please. Obviously, you want to be civil and professional in your discovery request, but this is a required process. The other side needs to participate in it, so there's no need to use words like please or things along those lines. Typically, a party is limited to 30 interrogatories, although many times the interrogatories will have subsections to them. So it's not an endless resource, and it is important to consider that as you draft your questions. It's very common in written discovery to use definitions and instructions. That can help avoid ambiguity, and it can also make sure that your net is very, very broad. It's going to capture all the data that you want. Okay, a discovery is going to have the same components that we had in pleadings. There's going to be an attorney's signature block, which we'll look at in a second. There's going to be a certificate of service. Keep in mind that it needs to be set up for the attorney's signature. And you're going to need to have a properly submitted transmittal letter, a cover letter basically for your discovery document. You're going to want to draft the letter so it is going to the attorney for the other party. If it's well, obviously that copy will go to that person, or if you are deposing a witness who isn't represented, you might also send it directly to that particular witness, and you'll want to CC any other parties to the case, I mean the other attorneys to the case. So here's an example of a discovery closure. We say respectfully submitted even though it's not being submitted to the court typically at this case. This is a common way to set it up. It's not the only way. You can see they say by, colon, and then the line. I would say more often than not you don't see the by, colon, but it's certainly fine to do. And you can see this attorney has typed her name and then her law firm. She's given her bar number. And by the way, you give your state bar number whether you're in state court or federal court. And then the location of her office. She has a telephone number and it's called telecopier, but really this is facsimile. And then you're likely to want to add at the bottom attorneys for whomever you're an attorney for. Even if just one name is present here, if the law firm has more than one attorney, all of the attorneys are representing that particular party. So it's appropriate to say attorneys for Bob Smith. So that gives you an overview about how to approach that. We don't file discovery requests or responses with the court routinely. There are certain situations where it's done, but it's not the usual course. If you have any questions, please feel free to reach out to me. I'll be happy to answer them. Okay, let's go back to our learning module file where it's still in module 10. So let me scroll down to there. Let's look at the assignment. Okay, so what is our assignment? Using the Notice of Taking Deposition document that you can find in the Sample Documents folder as a model, we're going to prepare a Notice of Taking Deposition. So that's going to be the name of our document, and we know our attorney's name, Throckmorton Miller. What a name. He practices with his law firm, and of course we're going to need to go and get the address for Miller, Cannon, and Marino. So I'm going to go over here to the sample documents. Here we go. So I'm going to click on Miller, Cannon, and Marino letterhead. And so this is going to give me the address. It's perfectly fine that it's not in Texas. That's not a problem. Obviously, Throckmorton Miller has to be admitted to practice in Texas if he's filing this in state court, but it's not unusual for an attorney to practice in one state and be a member of the bar in another state. Okay, so we found that address. Now we're going to go back to our learning modules. Go down here to 10. So again, we have found our example document. We found the address for Miller, Cannon, and Mourinho. And we've also gotten Mr. Miller's bar number. So those are some important pieces of information we'll want to use in our notice of taking deposition. The next paragraph tells us who our client is. He's Jamal Henderson. And we find out his role. He's obviously the plaintiff because he's suing. And the defendant is Walmart Corporation. We're going to get a few facts. Mr. Henderson was injured at Walmart when a rack of clothes fell on him, breaking his right arm. You are noticing the deposition of Lucy Daniels. So that's our person. A shopper who was in the area when Mr. Henderson was injured. Miss Daniels is not represented by counsel in this matter. I mean, why would she? She was just hanging out, just doing some shopping. Walmart, of course, is represented by an attorney. So who is Lucy Daniels? Think about that. Is she a party or non-party? Okay, here's the information about Walmart's attorney. We know his name is Derek Leone, and this is the name of his law firm. And here is the physical location. Now we get some information for the caption. We know what the district court number is. We know it's in Collin County, and we also have the cause number. All of that is information that's going to go in the caption. You've already contacted Mr. Leone and Miss Daniels. So this is Miss Daniels. She's the person who's going to be deposed. Mr. Leone is the opposing counsel in this case. And they've agreed to the deposition to happen at your offices. You may be thinking, well, how would they come to be in Florida? Don't worry about that. We're just going to assume that all works out. So work under the assumption that's where the deposition will be. It's going to begin at 2 p.m. and it's going to begin at the 8th of next month. You are going to mail a copy of the notice of deposition, certified mail, return receipt requested. Now, where are you going to put this information? What part of the document is that going to go in? Let's pull up our example. Look at this. There's a little typo here. There we go. Certified mail, return receipt requested. There actually should be a comma after that too. That's where this information goes. Let's go back. You should leave the certificate of service, the date of the certificate of service blank. Let's go back and look at that. Oh, so here we're going to need to make a change. Now you can keep, obviously our year is wrong here, but you can keep the year and you can typically keep the month. Now if this were going to be right at the end of the month, you might choose to also leave the month empty if you're not sure if you're going to be able to send it out. Let's say it's September 30th versus October 1st. You might leave it blank, but most of the time you're going to know which month it's going to be and certainly what year it's going to be, so you'll just have a space, and then when Throckmorton signs it, he's going to handwrite in that date. Okay, so that gives you an overview of the information. Let's look at this document. Let's look at some things that are kind of important to this document. There's no need to underline this, so I'm going to, as you've probably seen as we've done assignment or done here we go. As we've done situations like this, that you're going to want to clean things up. So there are things in here that may not be perfect. Don't assume that just because it's in this document that necessarily follows that this is the way to do it. Notice of taking deposition, this looks good. Look, it's centered. You don't have to capitalize every letter, but you need to capitalize the main letters. And sometimes knowing what is the rule about capitalizing can be confusing, so certainly capitalizing all the words ensures that you're going to get it right. You're also going to want to look at your footer. Oh, look here. Is that in the right font? Maybe I ought to change that. Then, of course, you're going to put in who is receiving this document. Who is it written to? Well, of course, it's going to be written to opposing counsel. And we have information about opposing counsel. Right back here, we have Derek Leone, and we have his address. Then we have the body of our document. It's common to, please take notice, to put in all caps. It certainly nothing magical about it, but that's a common thing to do. It's also common to have "you are invited to attend" in all caps. When you read this, you'll see it's not well written. Of course, you're going to do a better job writing it than poor Mr. Miller's previous paralegal. There's all kinds of passive voice and things like that you're not going to want to use. You're also going to want to make sure your genders are correct or there are any other issues. And you'll need to add a signature block here. Here's a certificate of service. I've managed to get this all on one page somehow, but of course once you add Throgmorton's signature block, it's very unlikely you'll be able to keep all this on one page. It's a best practice to have the certificate of service only appear on one page. And there will be times in your career where certificate of service is longer than a page, but this one isn't a long certificate of service. It's easily going to be able to fit on one page. So probably what you're going to end up doing is doing that, right? Getting it on the next page. You're going to want to center this, and you're going to want to you can list the date, say how you're going to be mailing it, and list who the recipient is, and then have a place for Mr. Miller to sign. So that should get you set up in terms of the content. Just be sure that you're looking at this and making sure this is how you want it to read. Don't assume that the model is awesome, perfect, amazing. As you know from previous assignments, it's pretty common for me to provide a document that isn't the best. You are empowered to improve the documents, and if you don't, you're probably going to lose some points. So definitely be aware that there's some opportunities with this document. I think that we've covered the things that we need to. Good luck with this assignment, and thank you for your attention. I'm going to go ahead and stop sharing my desktop. Thanks again.